Hello, I'm Calvin Koo, and this is your April 2023 crypto update. As a reminder, my thoughts and comments are strictly my own and not that of my employer. Nothing I say is intended as legal or financial advice. This month, we have a couple notable white papers from the US executive branch and a few notable enforcement actions. As you can see, some take the perspective that these developments, among others, suggest a concerted effort by the US to cut off and cut down crypto. But perhaps that's too extreme of a position, with the reality a little bit more nuanced. See what you think. Starting with the White House. In late March, the White House published the Economic Report of the President. In this 513-page document available online, there are a couple chapters related to the digital economy and digital assets. Chapter 7 is called Competition in the Digital Economy, New Technologies, Old Economics. And Chapter 8 is called Digital Assets, Relearning Economic Principles. You might be able to guess where the White House is going with this, especially if you've been following crypto winter and recent US government actions in this space. But let me highlight a few passages so that it's a little more clear how the White House views the current crypto landscape, balancing the technology's potential promise against consumer protection and regulation concerns. Before jumping in, as a reminder, the White House doesn't speak for the entire US government. It leads the executive branch, but there are potentially other views within key government agencies, Congress, and across state governments and agencies. However, obviously, the White House's views may carry material weight. So on to the report. Starting at page 238, the report says, quote, "It has been argued that crypto assets may provide other benefits, such as improving payment systems, increasing financial inclusion, and creating mechanisms for the distribution of intellectual property and financial value that bypass intermediaries that extract value from both provider and recipient. Looking under the hood at these arguments, however, shows a more complicated picture. So far, crypto assets have brought none of these benefits. Meanwhile, the costs generated by several of their aspects, such as those for consumers, the physical environment, and the financial system, are not only substantial, but are also being accrued in the present. Indeed, crypto assets to date do not appear to offer investments with any fundamental value, nor do they act as an effective alternative to fiat money, improve financial inclusion, or make payments more efficient. Instead, their innovation has been mostly about creating artificial scarcity in order to support crypto assets' prices, and many of them have no fundamental value. This raises the question of the role of regulation in protecting consumers, investors, and the rest of the financial system from panics, crashes, and fraud related to crypto assets. Even so, as companies and governments experiment with distributed ledger technology, DLT, it is conceivable that some of their potential benefits may be realized in the future, end quote. So that's pretty skeptical stuff. The White House's report then spends a few paragraphs walking through what it calls the, quote, perceived appeal of crypto assets, including investment vehicles, money-like functions without relying on a single authority, increasing financial inclusion, including for people who don't own a bank account, and improving the United States' current financial technology infrastructure. But then the report spends several pages in a section called The Reality of Crypto Assets, and the subtitles largely speak for themselves. Here are the titles. Crypto assets are mostly speculative investment vehicles. Cryptocurrencies generally do not perform all the functions of money as effectively as sovereign money, such as the US dollar. Stablecoins can be subject to run risk. Crypto assets can be harmful to consumers and investors. There have been limited economic benefits from distributed ledger technology. The report then says that while the crypto assets ecosystem and its underlying technology introduce the potential for newfound efficiencies, efforts to challenge basic economic principles have frequently resulted in financial calamities. A few pages later, the report goes on to summarize that although the underlying technologies are a clever solution for the problem of how to execute transactions without a trusted authority, crypto assets currently do not offer widespread economic benefits. They are largely speculative investment vehicles and not an effective alternative to fiat currency. Also, they're too risky at present to function as payment methods or instruments to expand financial inclusion. Even so, again, it reiterates it's possible that underlying technology may still find productive uses in the future. In the meantime, some crypto assets appear to be here to stay, and they continue to cause risks for financial markets, investors, and consumers. And much of the activity in the crypto space is covered by existing regulations, and regulators are expanding their capabilities to bring a large number of new entities under compliance. Side note, that's a reference to the Securities and Exchange Commission's perspective. Other parts of the crypto asset space require coordination by various agencies and deliberations on how to address the risks they pose. Side note again, this is citing the Treasury Department's work. So the report then says that certain innovations, such as potential US central bank digital currencies, or CBDCs, could help bring US financial infrastructure into the digital era in a clear and simple way without the risks of irrational exuberance brought by crypto assets, end quote. So basically, the report expresses great skepticism of crypto and its potential promises, though it leaves a little room for that to change. It also then acknowledges that there are digital deficiencies in the US financial infrastructure, but rather than have crypto itself as a solution, it raises alternatives like CBDCs and other more traditional technological developments. Now, next story, I mentioned the Treasury Department a moment ago. Treasury does fall under the executive branch, but it too recently released a report called the 2023 DeFi Illicit Finance Risk Assessment, which was published on April 6. It is described as the world's first illicit finance risk assessment about decentralized finance, also known as DeFi. Again, let me walk through some quotes and I'll annotate them. First, the report says the risk assessment explores how illicit actors are abusing DeFi, as well as vulnerabilities unique to DeFi. This is to help efforts identify and address gaps in the United States' anti-money laundering and countering of financial terrorism efforts. The report notes that the term DeFi is frequently used loosely in the virtual asset industry and often refers to services that are not functionally decentralized. So what they're saying is companies and products and code may say it's decentralized, but in fact, it may not well be. Back to the quote, the degree to which a purported DeFi service is in reality decentralized is a matter of facts and circumstances. And this risk assessment finds that DeFi services often have a controlling organization that provides a measure of centralized administration and governance. Now, this is incredibly important to note for legal, policy, legislative, and enforcement purposes, because some degree of centralization is often needed to make enforcement and regulatory mandates have bite, practically. So it's important that that's their perspective. The report adds, quote, a DeFi service that functions as a financial institution as defined by the Bank Secrecy Act, or BSA, regardless of whether the service is centralized or decentralized, will be required to comply with BSA obligations, including AML and CFT obligations. A DeFi services claims that it is or plans to be fully decentralized does not impact its status as a financial institution under the BSA. Moving on with this report, the assessment finds that illicit actors, including ransomware, cyber criminals, thieves, scammers, and North Korean cyber actors, are using DeFi services in the process of transferring and laundering their illicit proceeds. To accomplish this, illicit actors are exploiting vulnerabilities in the US and foreign AML, CFT regulatory, supervisory, and enforcement regimes, as well as the technology underpinning DeFi services. In particular, this assessment finds that the most significant current illicit finance risk in this domain is from DeFi services that are not compliant with existing anti-money laundering obligations. So, another annotation, this really here is the paper's lead point, even though later in a conclusion that follows 38 pages later, the report finally acknowledges that, quote, illicit activity is a subset of overall activity within the DeFi space. And at present, the DeFi space remains a minor portion of the overall virtual asset ecosystem. Moreover, money laundering, proliferation financing, and terrorist financing most commonly occur using fiat currency or other traditional assets as opposed to virtual assets, end quote. The report also talks about the ability to use data from the public blockchain in addition to the development of industry-driven compliance solutions for DeFi as tools used to mitigate some illicit finance risks. Indeed, blockchain data and forensics firm Chainalysis pointed out in response to this report that DeFi is actually a poor mechanism for money laundering and other forms of financial crime, given that all transactions are visible on-chain. The Treasury report's reply to that comment, in effect, is its statement in the report that such measures and the fact of transparency do not sufficiently address the vulnerabilities on their own, and that blockchain analytics, although encouraged for further development, cannot replace the importance of regulated financial intermediaries in applying AML and CFT controls. So we can see that the Treasury report presents all these risks first in its report, and that's perhaps unsurprising, but that's clearly their focus area, notwithstanding the facts that illicit activity in crypto remains smaller as part of the overall crypto ecosystem, and that the transparency aspects of the technology can help mitigate some of those risks. A few additional points from the report. It says that some industry providers may purposely seek to decentralize their services as an attempt to avoid triggering AML obligations. It also says that some services are developed with an opaque organization structure that may present critical challenges to supervision. And for cases in which DeFi services are not complying with their AML and CFT obligations, enforcement of applicable statutory and regulatory obligations may be challenging. So the report recommends strengthening US AML and CFT supervision, and where relevant, enforcement of virtual asset activities, including DeFi services, to increase compliance by virtual asset firms with Bank Secrecy Act obligations. The Bank Secrecy Act is the US's anti-money laundering law. The assessment finds that to the extent a DeFi service falls outside the definition of a financial institution under the BSA, that would be called disintermediation. And that too is a vulnerability that exists due to the reduced likelihood that such DeFi services would choose to implement AML measures. This too can then result in gaps in efforts by the DeFi service industry to disrupt and identify illegal activity, and identify and report suspicious activity to law enforcement and other competent authorities. Globally, under the standards set by the Financial Actions Task Force, or FATF, DeFi services that lack an entity with sufficient control or influence over the service may not be explicitly subject to AML CFT obligations, which again could lead to potential gaps for DeFi services in other jurisdictions. So the report recommends enhancing the US AML CFT regulatory regime by trying to close those gaps. But frankly, it's not clear how, as a practical matter, such gaps can be closed where a DeFi service is truly disintermediated. Now, the DeFi Education Fund tweeted in response to this report a few points from their tweets. The DeFi Education Fund said that at a high level, we believe that the assessment forgets at times that the existing BSA framework was developed based on how the global economy worked in the 1970s and is a means to an end, not an ends in and of itself. DeFi protocols allow people to engage in transactions in new ways, and an effective AML CFT response must acknowledge the fundamental functional difference between traditional finance and DeFi. The assessment seems to evidence a tension between the idea that decentralization is irrelevant in determining compliance obligations under existing AML CFT controls, and the idea that DeFi protocols are a novel tool unanticipated by existing frameworks. On the other hand, at certain points, the assessment does evidence a sophisticated understanding of the DeFi landscape that contrasts with its high-level takes. This may reflect differences in understanding among the many agencies involved in its finalization. And they exert a list of more than a dozen US federal and state agencies that were consulted for this report. They also discussed the clearly differing perspectives they have with the government on the value of privacy. Now, moving on, but staying in the US for another story, there have been a number of high-profile enforcement actions that have come out over the last few weeks. Coinbase said it received a Wells notice from the Securities and Exchange Commission, and that's a notice of likely enforcement action coming soon. And it gives Coinbase an opportunity to say why action should be brought. The notice itself was published, but was fairly vague on what precise securities law were allegedly violated. This week, the SEC also sued Bittrex, another US crypto exchange that had closed earlier this year for allegedly operating an unregistered exchange. The co-founder and former CEO, as well as the exchange's foreign affiliate, were also named as defendants. The SEC's Chairman Gensler said, the SEC has initiated these proceedings despite the fact that Bittrex Global has no US customers has never held itself out as doing business in the US or with US persons, and has taken pains to disclose to US persons that they are not permitted to use its exchange, end quote. This was all based on the entity's purported failure to register as a national securities exchange in connection with its operation of a single shared order book with Bittrex. Bittrex Global said it would vigorously defend itself. Also, a few weeks ago, the CFTC, or the Commodities and Futures Trading Commission, sued Binance for allegedly evading commodities rules and conducting illegal activity. Now, there's pretty extensive coverage of all of these stories online, but one observation of all the things I'd like to share based on the things we've covered today. Now, notwithstanding the policy reports that we reviewed and these seemingly multi-front regulatory actions, as well as recent bank failures that affected crypto and Web3 companies, it's one thing to say and acknowledge that in the current environment, as a policy matter, many parts of the US government appear to be leaning on the consumer protection focus of the issue and not on the support for a new industry side of the issue. Perhaps this is all unsurprising given a year of crypto winter. But it's also perhaps too extreme to say that the US government is a monolith with a unified and singular approach to effectively banning crypto or cutting it off from the market. As discussed, there are scores of agencies and government players, and while many currently are focused on their protection mandates, the fact that the CFTC is calling some tokens in the Binance suit commodities, while on the same day the SEC released an investor alert calling the same things securities, underscores how there isn't a unified approach across the US government. Also, just yesterday, SEC Chairperson Gensler was grilled by a US congressman during a House Financial Services Committee in Washington, with strong disagreement between Gensler and the committee chair on whether there's clarity in the security laws over crypto. So ultimately, many in the industry are frustrated about what they say is a lack of legal and regulatory clarity and the perceived multi-front attack, which may actually drive many crypto transactions away from centralized institutions. Ironically, this would support the original ethos of crypto evangelists that are anti-centralization. That in turn would harm AML and FATF focuses on deputizing centralized institutions to monitor compliance. So if all those transactions turn to DeFi instead, this would then circle back to the concerns that Treasury identified in its report. So we'll see where this all leads. That's it for this month. See you next time.